Welcome and thank you for joining Seyfarth's webinar, Changes Coming to the California Privacy Rights Act, What You Need to Know. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to John Tomaszewski. John, you may begin.
Thank you. Next slide, please. So as many of us know, and many of us have been hearing about a lot in the press, California is changing its privacy law once again. These changes are actually in addition to what has already existed under current California law, but they have a number of new concepts and new obligations and new areas of coverage that we think are going to be important for everybody who actually does business in California or has residents of California on their payroll. Next slide, please. So I am joined by two of my colleagues, Yana Komsitsky and Kathleen McConnell, who will be helping me walk through the changes in the California law. And they're both quite competent in their own areas. I will allow them to introduce themselves. I'm John Tomaszewski. I'm a partner in the Houston office and the co-chair of our Global Privacy and Cybersecurity Practice Group. And I've been playing in this space for a long time. So I'm one of the old gray hairs, but Kathleen?
I'm Kathleen McConnell. I'm a partner in our San Francisco office in our privacy and e-discovery group. I also head up our e-discovery analytics practice in addition to practicing extensively in privacy.
And Yana?
And I'm Yana Komsitsky, and I'm senior counsel in our Los Angeles office. And I am part of our awesome international employment law practice, which covers the globe. I happen to be in LA, but we've got folks all over and help with any country or employee issue that comes up.
Thank you. Next slide. So we're obviously going to start off with the concepts that currently exist in California law, as well as what some of the changes have been to the current concepts and some of the new concepts that have been added to the California law. We're also going to touch a little bit on the extraterritorial scope and application of the California law, and then we'll finally get into that space, which everybody on the call, I'm sure, is most concerned about, and that is, what do we have to do to comply? So next slide. The CPRA is the California Privacy Rights Act. It is somewhat confusingly named so because when you look at the new regulations, they're actually the CCPA regulations. Another name for it is Prop 24. And the way that the current agency is looking at the CPRA is it's really just an amendment of the CCPA. So ultimately, if you hear people talk about California law, they're going to use all three of those terms interchangeably. It's CCPA, CPRA, Prop 24. We're all talking about the same thing. We're talking basically about California Civil Code section 1798.100 et sec. Next slide. So what's new? The big thing that's new, and the reason why we have Yana especially on the webinar to cover some issues, is because what we thought was going to happen didn't happen, and that is the employee exemption for coverage under the vast majority of the California law is lapsing as of January 1, 2023. That means anyone who has an employee resident of the state of California is now going to be subject to the California law. We have a couple of additional things added to the substantive component of the law as well. There's now a new component which tends to track a bit of the European style laws around sensitive personal information, and two new things that we're seeing in additional laws in other states as well, and that is concept of collection limitation and purpose limitation. Historically, there was not a right to correct incorrect data. There will be now. And the new obligations that we're going to start seeing are an additional agency for enforcement and the affirmative rights around needing to have accountability mechanisms in place that are auditable. Additionally, there's the no secondary use concern, but that's similar to collection and purpose limitation. We can get into that later. Next slide. So one of the things that's always interesting to me when I talk with my European colleagues is they get really excited about how the GDPR has this strong extraterritorial application. And I kind of laugh a little bit because the United States has been excellent at having extraterritorial application for a very long time. We're used to this. So the idea is, if you're doing business in California and you're collecting information about individuals in California and you meet the definition of a business, you're going to end up being subject to the law. Well, what does doing business in California really mean? It means effectively if you are, quote, availing yourself of the jurisdiction. So this idea of intending to reach out and touch California residents. If you're employing Californians, that's clearly a situation where it doesn't matter where you're located, California citizens have rights and you're going to have to comply with those requirements. This is true in other areas of labor law as well. But basically the idea is it doesn't matter where you're located, it matters where the data subject is located. And if you are not blocking Californians, at least the way the California long arm statute works, you're probably purposefully availing yourself of the state of California. So the long arm statute is very broad, and as a consequence, a lot of people are impacted by it. Next slide, please. So great, it reaches all over the world, but who does it touch? So one of the things that did change between the old version and the new version of the law is the number of individuals that are the trigger point in terms of whether or not you're considered a business. So if you are any of the three triggers, if you cover any of the three triggers, then you're going to be considered a business and you're going to very likely be subject to California law. The first one is obviously, do you have gross revenues of 25 million or more? That's annual. It is not clear whether those are worldwide or just in California. The safe bet is consider it worldwide. So if you have annual gross revenues of 25 million or more, regardless of where your money is coming from, you're very likely going to be considered a business. The other one is if you don't have $25 million in revenue, but you buy, sell, or share for commercial purposes personal information of 100,000 or more consumers, that also would trigger you being a business. That number has gone up. Prior to 2023, it was 50,000, not 100,000. And the concept of buy and share has also changed a little bit. We'll get into that in just a little bit, but the idea basically is if you are allowing somebody an independent right to use data, very likely you're going to end up either selling it or sharing it. So for example, if a service provider is using data to provide you services, that's not a buy or a sell. But if you give them rights to use that data for their own capacity to earn money, that's a buy or sell, even though they're your service provider. And then obviously the last one is focused on small startups that are primarily in the data industry. Currently, it doesn't apply to most nonprofits. There is one exception, which is if you are a member benefit not-for-profit organization under California law and the members can pull money out of the member benefit organization, you're likely going to be viewed as a business anyway. And then obviously, as we talked, the concept of the long arm statute, which is purposeful availment in the jurisdiction, that's going to mean you're a business, even if you're not in California, if you hit any of those triggers associated with California individuals. Note that the 100,000 or more consumers or households is California consumers or households, not consumers or households anywhere. Next slide, please. So what's a consumer? This is actually pretty easy. Basically, if you pay state income tax in the state of California, you're a consumer for purposes of California. As we've talked about previously, prior to January 1, 2023, there was an exemption for employees for the vast majority of the requirements of the CCPA. That is not true anymore, which basically means if you're a labor and employment lawyer, you're now going to have to be a privacy lawyer for California. Next slide. So with this, I'm actually going to turn it over to Kathleen so she can actually walk through in a little more detail in terms of what's changed.
So In terms of what type of information is covered by the CPRA, the scope really includes any information that relates to, describes, is capable of being associated with, could be linked directly or indirectly with a consumer or a household. This is really a very broad definition. It includes all kinds of identifying information, address information, email address information, IP address information, social security, kind of things that you think of more classically, like socials, driver's license, passports, passport numbers, and those types of things. But it also includes all kinds of things that we are not quite as logically assumed. So information about whether people fall into certain protected categories qualifies. Commercial information, like your buying, your selling history. Educational information falls within this. Geolocation information falls within identifying information. And very interestingly and very importantly, inferences based on behavior also fall within the scope of identifying information here. And when we say inferences based on behavior, that's the type of information that you or a company can gather from the information that they have, such as whether somebody is married or what types of things they might be interested in. So basically things that you could build a profile off of based on other information that you have or have collected. So it's a really, really broad definition of information here, of personal information here. In terms of things that are being added with the CPRA, we also now have a category of sensitive personal information. And as we can see on the next slide, sensitive personal information kind of takes this whole definition to a whole new level. So it includes some of the subcategories of things that fall under personal information, such as socials, driver's license, and those types of things. But it also encompasses more specific categories, such as account login information, some more specific financial information like debit or credit card numbers, combinations of things that would equate to logon information, such as logon information combined with a password or credentials. That's another thing that's kind of new falling within the scope of this, and that'll tie into some of our data breach information and remedies later. Precise geolocation information is considered sensitive personal information. Racial, ethnic, religious, union membership, that all falls within the information of sensitive. Contents of email and text messages is sensitive information. And then also we've got genetic, health, and sex life orientation data that falls within sensitive. And the reason that sensitive personal information is different and you need to be aware of it is that there are some additional requirements that exist around what you need to do and disclose and for data that is sensitive as opposed to just more general personal information. Next slide, please. I'm going to turn it over, I believe, to Yana at this point.
I think we've got John for this one.
Yeah, I was about to say I'm gonna grab this one real quick because this concept is one we get a lot of questions around, and part of the reason for that is the definition of sale is really broad. It's not what we normally view as a traditional concept of a sale, which is somebody comes to you and says, hey, you've got an email list, I want to license your email list and use it for marketing purposes. Clearly that's a sale, but that's not the only thing that is going to be viewed as a sale. The concept of sharing was added as part of Prop 24 because they were trying to get to the concept of cross-contextual behavioral advertising in the definition of sale, but it was so confusing nobody could figure out what the heck was going on. Unfortunately, they didn't change the definition of sale. So the concept of sale is really one where in the event that a third party has access to data, and it can be in writing, it doesn't have to be electronically, okay? And that access to data has some kind of valuable consideration around it. And for those of us who are American lawyers, we know consideration can be very small. It does not have to be anything larger than maybe a potential decrease in the value of the services provided. But the idea is if you have access to data, and there is some level of consideration around that access to that data, then it's potentially a sale. Now, a lot of folks get into trouble because they go, oh, well, I'm a service provider. I'm using data to improve my services. Does that necessarily mean that I'm selling or not selling data? Fundamentally, the idea is in the event that the service provider has the ability to use data to make money with some other client, either because their services are improved or they're going to actually be able to leverage a new set of algorithms because and sell those to some other third party, or they're going to use the data actually to, in the instance of an affiliate ad network, do marketing for third parties, other members of the ad network. That's going to be considered a sale, even if there's not necessarily money transfers. If there's some sort of valuable consideration, if there's some sort of benefit that exists in the transfer, that's going to be viewed as a sale. So what this basically means is if you've got service providers, for example, analytics companies that have independent rights for data use outside the scope of providing you services, if they can use your data for some other service for some other party, it's very likely going to be a sale. So that's the idea. Really what we're needing to look at in terms of sale is are there independent rights of use and leverage for the data that's used associated with the services you're getting? If there are, it's very likely going to be a sale. If there aren't, and you can do this in your contract with your service provider, then it won't be a sale. Share is really the new concept, because when we all think of share is just having access to data generally. And of course, California, doing what California does, they actually decided to define share very specifically. It's not just disclose or access, which is the normal definition of share. It's got a specific purpose limitation associated with it. And this purpose limitation is for the purposes of cross-contextual behavioral advertising. What this means is cross-contextual is from one website or one brand to another. So you can do behavioral advertising within your own web property. You can do behavioral advertising within your own brand. You just can't do behavioral advertising across brands and across web properties. So that's the idea of share. The interesting thing on the distinction between sale and share is sale doesn't have a purpose limitation. If there is any valuable consideration around third-party right or secondary rights to data, it's probably going to be a sale, and there are going to be limitations around that, for example, an opt-out. Share doesn't have the consideration component, but it's got a purpose limitation component to it. So it's important to recognize that even if you're not disclosing data associated with cross-contextual behavioral advertising, you still may be doing a sale. And even if there's no valuable consideration in play, you still may be doing a share. So these are things that are really important we have to think about in terms of how the data flows. So next slide.
So there's some significant new limitations on data usage. These limitations are somewhat novel for us here in the US and California, even though they would be quite familiar to those of us who have been working under the constraints of the European privacy laws. The first we want to mention is purpose limitation. A business should be prepared to disclose all purposes for which personal information is collected and ensure that it's using the data only for those purposes. If there is a new purpose, it must be disclosed to the consumer. And when I say consumer, I really want to be clear. We also really mean employee or applicant or contractor. And so it must be disclosed to that person in a new notice. And we should work on the assumption we're talking about meaningful disclosures rather than broad statements like for all of our business purposes, although the wording used will vary depending on who's doing what. The next important one that can be hard to commit to is collection limitation. A business should only collect personal information that is necessary and proportionate to achieve the purposes for which the information was collected, or for a compatible purpose. So the business shouldn't be collecting any more information than it needs to accomplish a certain goal, which can be hard for us in the US to conceptualize. For personal information of employees, based on what we know about how employee data is used, this is going to be an ever-lurking danger. As we've seen in the European space, TA, HR, marketing, and others may approach additional uses more liberally than they might do with true consumer data. And storage limitation, finally, the business needs to comply with storage limitation principles. This generally means deleting the data when the purpose for the collection has run its course. It's also a compelling argument to implement or beef up any enterprise record retention program, which would operate as a set of rules for how long each type of data or record is retained and why, and not by reference to a broad however long is necessary, but ideally by reference to the legally required record retention period specific for that type of data, for instance, a statutory minimum period or the statute of limitations. And that's in order to justify the duration of storage. Next slide. So the data subject rights, some of these already exist and some of these are expanded under the CPRA. So for employees, these are new. Rights include rights to know and access the categories collected, the sources, purposes for collection, categories of third parties to whom the business discloses the data or the PI, the specific pieces of information it has collected, etc. The right to deletion, the right to opt out of sale, which John just got into a little bit. The right to non-discrimination, including retaliation against an employee, applicant, or independent contractor for exercising these rights with their employer, and data portability. I think we'll move to the next slide. We skipped, let's go back. I'm going to rush through the new rights: rectification and correction, opt out of sharing for cross-context behavioral advertising, limit use and disclosure for sensitive personal information, and opt out of the use of automated decision making. I think we touched on some of these, and we should be aware they exist. Behavioral advertising one will require certain decisions related to the do not sell link required for businesses that sold PI under CCPA, or browser opt-out preference signals, which should be treated as valid requests by the consumer to opt out of sale or sharing. And there's some exceptions, and all this will look differently for employees, but we should be aware that these rights exist at the very least. Next slide. Next slide. So what are the business obligations? We can think of the obligations as comprising three general duties: the duty to comply with notice requirements, informing consumers of data handling practices, again, including employees, and this includes all the categories of PI collected, the purposes, and some of the things we've discussed. And responding to consumer requests, exercising those rights or attempting to exercise those rights. Duty to protect the security of the PI, implementing reasonable security procedures and practices appropriate to the nature of the personal information, to protect the information from unauthorized or illegal access, destruction, use, modification, or disclosure. And the hard ones, duty to train employees and contract appropriately with third parties in a compliant manner. So for instance, if the business sells to or shares with a third party or discloses PI to a contractor or a vendor for a business purpose, it must enter into an agreement with that third party that specifies the PI is disclosed only for limited or specified purposes. The agreement must pass certain obligations, grant the business the right to take reasonable and appropriate steps to help ensure compliance and remediate non-compliance or unauthorized use, and additional matters. Let's go to the next slide. So importantly, these rights that we've just talked about are not absolute. A business should develop standards detailing when rights requests will be honored or when they cannot be honored. Generally, you should delete unless, if we're talking about the right to deletion, which a lot of requests amount to that, unless this proves impossible or involves disproportionate effort. A service provider or contractor using information in the context of providing a service to a business may have an out. You're also not required to comply with with a deletion request, if the information is reasonably necessary to complete a transaction, provide a good service, help to ensure security and integrity, debug and identify errors, and importantly in the employment space, exercise free speech or ensure the right of another to exercise the right of free speech or exercise another right provided for by law, which is incredibly broad, potentially, to enable solely internal uses that are reasonably aligned with the expectations of the person whose data it is, and to comply with a legal obligation, also potentially very broad. I should note that those are exceptions or carve-outs for the right to, or excuses really, to avoid deletion or reject a deletion request. We do not have all this available to us to respond in a negative fashion to a right to know or access. So employers in particular are going to come across rights to know or access and really have very limited ability to deny those requests in the employment context. Next slide. I think now we're on to Kathleen, who's going to talk about security and audit requirements.
So one of the aspects that we see under the CPRA is a security requirement that's really should be very familiar to those of you that are doing business in Europe and similar to GDPR requirements, in that wherein a business that collects a consumer's personal information is now required to implement reasonable security procedures and practices. And there are a couple of requirements that come along with that. In addition to making sure that you need to ensure that you've got reasonable security procedures and practices in place, there are now audit requirements and risk assessment requirements. So to the extent that a company, an organization has personal information that might present a significant risk for consumers' privacy or security, there are requirements that annual cybersecurity audits be completed and submitted to the CPPA, because we needed more similar confusing acronyms involved in this assessment. The audit does need to be independent and thorough. So that's one of the things you need to keep in mind when you're setting up your audit parameters. And things to keep in mind about the risk of your PI processing operations are the size and complexity of the data processing activities that the organization is engaging in, and also the nature and scope of those data processing activities. The more sensitive the information is, the more stringent and more likely you are to have to fall under these requirements. You also have to conduct regular risk assessment to evaluate processing activities. And those are very similar to DPIA requirements, again, for those of you that are already doing business in GDPR affected areas. So really a takeaway here is heightened security requirements, heightened reporting requirements on a regular basis under CPRA, such that we haven't really seen to this level in the past. And if we could look at the next slide. Oh, the CLE code, very important. All right, so the CLE code is SS, as in Seyfarth Shaw, 8729. Again, that's SS 8729. And next slide, which I think our last slide, we're going to briefly touch on enforcement and fines. The enforcement and fines are similar to what was set up under the CCPA. The enforcement body has changed from being enforced by the Attorney General to being enforced by the CPPA, which is the California Privacy Protection Agency, who is also the body that is tasked with the regulation creation that we are still waiting on finalization for. Basically, CPRA keeps in place all of the fines that were in place under the CCPA, up to $2,500 for each violation and $7,500 for each intentional violation, along with statutory damages in the range of $100 to $750 per violation. We also add additional violation penalties available for consumers under the age of 16. And we do see a removal of the 30-day cure period. And in addition to the private right of action that there exists for breach-related activities. Otherwise, you're still in the realm of fines and regulatory enforcement as opposed to private rights of action. But there is a private right of action for breach-related activities, and that the scope of what's considered a breach is expanded under CPRA as well. We are right at 12:30 and we're committed to not going over. So I'll leave it to John and Yana if they want to add anything in quickly here at the end.
Yeah, the only thing that I'd clarify is the breach activities that there's a private right of action for are security breach activities, not breaches of the other sections of the CPRA.
Very important clarification.
Yes.
Thank you, John, for that add.
But other than that, I don't have anything additional to add. Thank you very much.
Excellent.
Thanks,
Thanks, everyone. Have a good afternoon.